Yeah, so just before being log off, we're still discussing the standard of care, and I was expanding on what is known as the Bolam test, which was developed in the Bolam against the Foreign Health Authority case. And I cited Justice McNair, who was making the point that, quote, in the realm of medical diagnosis and treatment, there is ample scope for genuine difference of opinion. And one man clearly is not negligent merely because his conclusion differs from that of other professional men, or because he has displayed less skill or knowledge than others who have shown. The true test for establishing negligence in diagnosis or treatment on the part of the doctor is whether he has been proved to be guilty of such failure, as no doctor of ordinary skill will be guilty of if acting with ordinary care, unquote. In other words, what Judge McNair in Bolam was trying to suggest was that for us to conclude whether what the particular healthcare professional has done is negligent or not, we needed to find out, will other reasonable doctors in the shoes of this particular doctor or healthcare professional will have behaved in the same way? If the answer is yes, they will have conducted themselves in the same way as this particular healthcare professional conducted himself. Then you could not conclude that he was liable or guilty of negligence. Of course, this has been problematic in the sense that if you look at other areas of negligence, it's not necessarily the case that way. But the worry which scholars and practitioners have as far as the Bolam test is concerned is this, that it appears a different standard of care, more or less, is being propounded for healthcare professionals or doctors when it comes to, oh my, this thing is frozen again. Okay, I don't know, it's not. When it comes to medical negligence, because whenever you sue someone, all that the person needed to do is to bring other doctors or other healthcare professionals who are prepared to, for example, take an oath and say that if I was in the shoes of this particular healthcare professional on the day in question, I would have done the same thing as he or she did. Once you could get a number of doctors to come and take an oath and testify in that way, you'll be able to escape, be able to get off the hook. So I'd like to find out from you, is it a good idea for the Bolam test to have attempted to create a different standard of care for doctors when it comes to medical negligence? I'd like to take some thoughts here. Maybe I take two men and then two ladies. So the ladies first. Is it a good idea to have a different standard of care for doctors in trying to establish negligence along the lines of the reasoning in the Bolam against Federal Management Committee? Yes, we will take the first shot. You want to speak, just raise up your hand, then I'll release you, or I'll just call. Any volunteer? Okay, Afia Banahene. I think she has left. Okay. Any other person? Are we together? Johnson, Ifa?
Yes, sir.
Yes. Let's hear your thoughts.
Sir, it's a yes and no. Yes, because medical profession is not just any profession, it's a technical area which, when left in the hands of ordinary people, will not be able to appreciate the details of the profession very well.
Oh, okay.
So we hope on the people in that profession to be able to tell whether or not the person actually was negligent. However, it also gives the medical professionals the chance to cover up their colleagues, and for that matter, if there's they cannot give up themselves just like that to ordinary people. And so I believe it was good because of the nature of the profession, and it was also not good because it will afford the medical people the chance to kind of cover up certain standards for themselves, which will not be good. To take away from the court the adjudicating powers.
Right. Right. Thank you, Johnson. Yes. Any other? Yes, Amadensha. Amadensha, you can mute. Yeah.
Sir, please, I don't think it was a good thing for the Bullam's case to develop a new standard of care for medical professionals, because I don't think the duty is very strict on the nature of work that they do, because we know that medical professionals work or deal with human life. And so I believe that we should rather hold them to a much stricter standard of care to ensure that human life is preserved, like the sanctity of life is preserved. Because if we are saying that it's okay for a doctor to get away with negligently treating a patient for a lack of skill in a certain area, or just because he wouldn't deal with a situation the same as a whole body of opinions or a whole body of professionals would, I would rather suggest that the standard of care would be stricter on medical professionals. And I don't think the Bullam's test does that. I feel like it gives them a little leeway to get away with certain negligent activities. So that is my opinion.
Right. Okay. Thank you very much. Yeah. Yeah. So if you, yes, any other, I said four. So I have two now, Amadensha, and I have Ifa. Who else? Okay, if you are not expressing your thoughts with all of us together, if you have to express your thoughts individually and to me alone, so that will come. Okay, right. So one noticeable thing about this Bullam test is that if you look at all other cases of negligence, it is the court which actually will formulate the standard of care. But in the case of Bullam, if you scrutinize it closely, you notice that it's like the medical profession has been given the power for them to determine what the standard of care is instead of like the court. It's like the medical profession has taken over the role of the court when it comes to setting the standard of care in order to determine whether there was a breach of duty of care. So that is the difficulty. That is the difficulty. It's like, and that is why some people will say that by the Bullam test, the the courts or the judges had adopted what we call the non-interventionist approach, in the sense that the Bolam test allows professional colleagues to substitute their judgment for that of the court. And what is even more worrying is that it does not prescribe a certain number of medical professionals who should agree with a particular way in which this defendant medical practitioner behaved. So long as you could bring some medical professionals to testify that you have done it the same way, you'll be able to get away with it. That is one thing which is really worrying, which is really worrying. And that was why in the House of Law's decision, in the case of Maynard against Westlands, right, decided in 1984, the court needed to consider how to treat the medical evidence directly. And what happened in the case of Maynard against Westlands? Let me say a few things before we move on. In Maynard against Westlands, two consultants were treating the patient for a chest infection. And the consultants believe that the patient was suffering from tuberculosis, but thought that there was a possibility that she was suffering from Hodgkin's disease. The doctors among us, when I finish, will tell us about what Hodgkin's disease means, which is fatal unless treated early. As a result, the consultant decided not to wait for the test to see whether the patient had tuberculosis, and instead conducted an exploratory operation, what they call it, the laparoscopy, to test to see to test for the Hodgkin's disease. The operation was carried out properly, and the patient was shown to have actually had the tuberculosis rather than the Hodgkin's disease. So later on, the plaintiff sued on the basis that the decision not to wait for the test for the tuberculosis have been negligent. So if you look at it, they've run a test for tuberculosis instead of waiting to know the outcome. He decided to quickly do exploratory surgery or laparoscopy in order to find out if they will find evidence of a Hodgkin disease, because of course Hodgkin disease was said to be fatal, and if it was not diagnosed and treated early, that could mean the death of the patient. But eventually, when they did it, they didn't find evidence of the Hodgkin disease. They rather found evidence of tuberculosis. And later on, the patient, for example, decided to see that they have been negligent in not waiting for the test of the tuberculosis and yet rushing to open up the patient to do the exploratory diagnosis. Now, during the trial, the judge at the very first instance, that the trial judge was very impressed with the plaintiff's expert witnesses, the doctors that the patient assembled. And those witnesses, that is the other doctors, said that the case had almost certainly been one of tuberculosis, and that to carry out the operation before the results of the test, for it had been it would have been like dangerous and wrong. As a result, the trial judge found for the plaintiffs, but the matter went to the Court of Appeal, and then the Court of Appeal reversed the decision. And then the matter eventually went to the House of Lords. That is the equivalent of the UK Supreme Court as at the time. And when the matter came to the UK Supreme Court or the House of Lords in the Maynard against West Midlands, the rare issue before the court was quite simple. And the issue was this: was the judge entitled to fine for the claimant despite the existence of medical evidence for the defendant? In other words, the plaintiff, that is the patient, should the patient be held entitled to judgment against the defendant, despite the fact that there were other medical doctors who said that what the doctors or the hospital did was not something wrong, and that was like the best in the circumstances, having regard to the fact that if they had waited to know the outcome of the tuberculosis tests, it could have been dangerous and wrong, especially so if it had turned out to be Hodgkin's disease as they initially suspected. So now the court was torn between two differing opinions, right? One body of medical doctors saying that, yes, it was right for the hospital not to have waited to know the outcome of the tuberculosis. It was right for them to have undertaken the operation or the exploratory surgery or the laparoscopy to rule out the Hodgkin's disease. There's another group of doctors who also thought that it was not necessary as it were. But the House of Lords made the point that just because a judge preferred one course of action to another was not a way to determine negligence. In other words, insofar as you have two competing opinion, one body of medical opinion saying that it was not necessary, another body of opinion saying that it was necessary, the court said that the trial judge should have given the benefit of the doubt to the medical profession and should have actually refused or to hold the doctor liable for negligence, because there was a body of opinion which says that by doing the exploratory surgery, there was nothing wrong. And don't forget, Bolam was trying to say that insofar as what the doctor in question did, insofar as what the doctor in question did is something which other doctors placed in the shoes of that particular defendant doctor would have done, then the defendant doctor could not be said to be liable for negligence. And for that matter, the view or what we witnessed in Maynard against West Midlands, having two differing medical opinion, meant that no negligence had been committed, and that was actually endorsed. So you see Maynard against West Midlands as being an endorsement, as it well, by the House of Lords of the test propounded in the Bolam case. Mind you, Bolam was decided by the High Court, not by the Court of Appeal or the House of Lords. But 1985 gave the House of Lords opportunity to actually give its blessing to the Bolam principle, which had been instituted in 1957. But let me emphasize that not all judges, right? Not all judges are excited by the Bolam test. We have to note that. And I referred you to the case of Sidaway, if you remember the Sidaway case, I refer to the case of Sidaway last semester, when we were learning about the informed consent test and then the prudent patient and so on. And you notice that Lord Scarman, for example, always had his own position as far as some of these matters are concerned. So if you look at the Maynard case, if you go and read the full judgment, you will notice that somewhere in his opinion, Lord Scarman, who was part of the panel which decided the Maynard against West Midlands, will say, and I quote, "I have to say that a judge's preference for one body of distinguished professional opinion to another also professionally distinguished is not sufficient to establish negligence in a practitioner whose actions have received the seal of approval of those whose opinion honestly expressed, honestly held, were not preferred." If this was the rare reason for the judge's finding, he erred in law. For in the realm of diagnosis and treatment, negligence is not established by preferring one respectable body of professional opinion to another. Failure to exercise the ordinary skill of a doctor in appropriate specialty, if his specialist is necessary. In other words, the court was saying that, yes, if you have a negligence case, the patient as a plaintiff has assembled his professional doctors to come and testify that what the particular doctor did or did not do on the occasion in question amounted to breach of duty of care. Now, insofar as the defendant doctor, the health care profession or the hospital, will also be able to bring other equally respectable body of doctors to come and say that what he did was quite consistent with what they too have done if they had been in that situation, then you cannot conclude that such a doctor, for example, was guilty or liable for negligence. So that is the rare difficulty. So here, you notice that it's like doctors have become more or less like non-touchables. They are allowed to set the rules of the game for themselves. They determine when a person can be said to be liable for negligence or not. Now, this actually has been quite problematic, as I have indicated. And you notice that in subsequent cases like the Sidaway against the Royal Bethlehem Hospital, the court applied Bolam test, but that one was in relation to the issue of disclosure. In other words, if a patient had come to you for treatment, how much information should you disclose to that patient? And Sidaway said that we have to use the standard, the Bolam test. In other words, will other doctors, respectable body of doctors, in the shoes of this particular doctor, that's the Dr. Consultant Farconer in the Royal Bethlehem Hospital in that case, will they have, for example, considered it necessary to tell the patient about the risk associated with that particular procedure? If a respectable body of doctors in the shoe of this particular doctor will not have considered it necessary to make such a disclosure, then the doctor in this case, Dr. Farconer in the Royal Bethlehem Hospital, had not committed medical negligence. But of course, you know that Lord Scarman disagreed with that, because Lord Scarman was actually trying to follow the principle which had gained traction in the North Americas. That is the prudent patient test related to the informed consent. And he was of the view that the patient was entitled to be informed of the risk inherent in the treatment. But you appreciate that Lord Scarman's dissenting opinion had to wait for how many years? This was expressed in 1985. He had to wait until 2015. I think that is almost over 30 years before in the case of Montgomery against Lagnache, if you remember, we read the last semester, Montgomery against Lagnache, before they will agree with Lord Scarman that when it comes to disclosure of information, the appropriate standard is not what other doctors will have considered necessary to disclose or not to disclose, but what a prudent patient, what a reasonable patient will have considered necessary for him or her to be able to make a proper decision as to whether to consent to a proposed treatment or not to consent. And that is the test. Yeah, so you should take note of that. And of course, last semester too, you read that as well. Yeah, you've seen the what do you call the cases of disclosure when we discussed informed consent last semester. So we are not going to belabor that point. Suffice to say that in the course of time, I mean, you know, Midland against Maynard against West Midland, decided in 1985, which sort of gave blessing to Bolam, decided in 1957, had actually come under serious criticism by scholars. So in 1997, some of the judges began to reason cautiously and began to qualify or modify the Bolam test. And one particular case in which the efforts of judges to try and modify the Bolam test reached significant height or crescendo is the case of Bolaito against Hackney Health Authority. Bolaito, the court decided to be more rigorous, right, in using the Bolam test. And what do you mean by that? In Bolaito, the court decided to say that, yes, if the defendant doctor can get the respectable body of opinion to say that they will have done what he did, that is something important. But we are not just going to stop at that. We are going to subject the body of the the respectable body of opinion to logical analysis. If we examine it and it can withstand logical analysis, then we will uphold what the respectable body of medical opinion saying, that they have done it the same way that this particular defendant did it. On the other hand, if we scrutinize it, if we examine it and it cannot withstand logical analysis, then we are not going to accept it. This simply because a certain number of doctors have come forward to say that they have done that which the particular patient did. Yeah, so if you remember, and again, Bolaito also have been read last semester, so you have to read it again. So in Bolaito against City and Hackney Health Authority, decided in 1997, Master Patrick Bolaito, who was 2 years old at the time, suffered from a bout of crop, and then he went to the hospital. He was released, but returned the following day due to breathing difficulties. He had further treatment and appeared to be progressing well. The day after the treatment, he suffered 2 episodes where his breathing appeared to be obstructed, and the nurse called the senior pediatrician and the senior house officer, who is a junior officer or junior doctor. Neither of these came to the patient. So the patient suffered a 3rd episode, where again, the 2 professionals did not attend when so called. And this led to cardiac arrest and brain damage. During the trial, the defendant accepted that there was a breach of duty in not attending to Patrick Bolaito. However, their case rested on causation, and they stated that even if they had attended, if the senior nurse and then the junior doctor had attended, they would not have intubated Patrick, which the medical evidence stated would have been the cause of action that could have prevented the cardiac arrest. During the trial, there was evidence that, okay, if Patrick had been intubated, then the cardiac arrest would not have actually occurred. But during the trial, the doctors or the junior doctor and the nurse who failed to attend, they testified that, well, if we had even come, we would not have intubated Patrick Bolaito. So the outcome would not have been different. Now, the question for the court was whether it would have been reasonable not to have intubated Patrick Bolaito. So, as is usually the case in medical negligence, the plaintiff brought their expert witnesses, that is other doctors, to come and testify what would have been the case. And then the defendant, that is the healthcare facility and the doctor defendants, also brought their expert to come and testify what would have been the case. Now, unlike the usual adherence to the Bolam test, as we saw even in the case of a Maynard against the West Midlands, and then the court said that if you have a differing medical opinions, it's not up to a judge to prefer one to the other and come to conclusion that there was a medical negligence. No, you just have to more or less give benefit of the doubt to the doctor and say that there was no negligence. Now, in Bolaito, Lord Brown Wilkinson, who spoke extensively for the court, took a different view. And this is what Lord Brown Wilkinson said, and I quote, in the House of Laws, quote, "The court has to be satisfied that the exponents of the body of opinion can demonstrate that such opinion has a logical basis. In particular, in cases involving, as they so often do, the weighing up of risk against benefits, the judge, before accepting a body of opinion as being reasonable, responsible, or respectable, would need to be satisfied that in forming their views, the experts have directed their minds to the question of comparative risk and benefits and have reached a defensible conclusion on the matter," unquote. In other words, Lord Brown Wilkinson in the Bolaito case was trying to say that the Bolam test should not be applied slavishly, and the Bolam test should be applied having our logical lenses put on. That is to say that if experts are put before the court should not just take what the experts are saying at face value. The court should be interested in probing the logical basis of the claims or the opinions which the experts, for example, are expressing. And if the court, for example, gets to know that having regards to this information or that information, someone who is an expert cannot reasonably hold such opinion, then the court can, for example, disregard that. So this is actually making good progress, that now the courts are trying to avoid checking their responsibility and just endorsing medical difference, or just deferring to the doctors, just allowing the doctors to determine the goalposts. Now the court are saying that as much as will listen to responsible body or respectable body of medical opinion. We need to be convinced that there's a proper logical basis for holding such opinion. And for that matter, if we test the logical basis of the opinion and we find it to be wanting, we are not going to say that what the particular doctor did will have been repeated by other experts or other doctors. So let us keep that in mind. And Bolaito actually was followed in a lot of cases for a long time until eventually we make progress. I mean, the cases are many, but just because of our discussion, I cannot discuss all of them one after the other. Otherwise, we will never finish what you are doing. But as you go and read the case of Montgomery against Lagnashe, which we saw last semester, you will notice that the courts have actually revealed the trajectory or the path along which the Bolam test had developed through various case law until 2015, when the Bolam was given a cool degrees, as it were. But before I move on, when you come to Ghana, right, the case of Jan, the case of Jan, and even the recent case involving 37, which I gave to you and all that, our courts are still following the Bolam test. If we examine medical negligence, the field medical negligence before the course in Ghana, you notice that more or less the Bolam test is still being followed. And it appears that our courts have not actually woken up to the various criticism and subsequent modification which the Bolam test has actually undergone. But we come and discuss the few Ghanaian cases. We will critique them in tutorial in the light of these discussions that we are making, but let us move on. So before we move on to causation and defenses, is there any question? Okay, so now let's look at the third element. We've established the breach of duty of care, and we said that to establish breach of duty of care, you need to actually have a standard of care. And we noted that the predominant standard of care, as far as medical negligence is concerned, is the Bolam test, which has undergone some modification through Bolaito up to Montgomery and Lagnashe. So we now want to discuss the third element of medical or clinical negligence, which is resultant injury or consequent injury. And of course, related to that is the question of causation, the question of causation. In other words, it is not enough for you to show that the doctor or the healthcare professional or the hospital owed your duty of care. Neither is it enough for you to show that the way or the manner they behave on a particular occasion amounted to breach of that duty of care. But more importantly, you must also demonstrate that the injury or the wound that you are complaining about, for example, emanated from the breach of the duty of care. So causation is very important. Causation is very important. You need to show the nexus. You need to show the link between what you are complaining about and the breach of duty of care that you've established. And again, since you are asserting, you have the burden of what? Of proof. So if we look at the section 10, section 11, section 12, section 14, and section 15, as well as even section 16 and 17 of the Evidence Act of 1975, NRC Decree 323. You, the patient, that is a plaintiff, who is trying to assert that the injury that you are complaining of is as a result of the breach of the duty of care. You have the burden of proof, and you have the burden of producing evidence to establish that in the mind of the tribunal of fact. So let us keep that in mind. Good. But the good thing is that when it comes to causation in negligence, even in general negligence, in trying to show that the tortfeasor, in this case, the treating clinician or the doctor, healthcare professional, or the hospital, was responsible for the particular injury which the plaintiff is complaining about, you can resort to what we call the Bad-Ford test. You all know the Bad-Ford test very well. The Bad-Ford test simply means that the defendant is saying that he or she will not have suffered that which he or she is complaining about, but for the negligence or the breach of duty of care which the defendant actually committed against the plaintiff. So that is the Bad-Ford test. But the difficulty when it comes to clinical negligence or medical negligence is that the patient as a plaintiff needs to distinguish between, one, the effects of the alleged negligence, and two, the patient's pre-existing condition. It may well be that the injury which the plaintiff is complaining about emanates from pre-existing condition. So those are some of the things that we need to grapple with, isn't it? And when it comes to the human body, as we know, so complex. Maybe there's a certain incident or underlying condition you have so many years ago. And yes, there was a breach of duty of care, but let's suppose that the breach of duty of care is not necessarily responsible for the injury that you are having, but because of a certain pre-existing condition and all that. So these are some of the difficulties. But let us say a few words about the basic components of the law relating to causation. So first, we have made the point that as a general rule, the plaintiff or the patient plaintiff can invoke the Bad-Ford test, which was propounded in the 1969 case of Barnett against Chelsea and Kensington. Barnett against Chelsea and Kensington. If you remember, there, the defendant made argument that it was the plaintiff's condition itself that caused the injury. If you remember that case. And basically, the facts were that we had a 3-night watchmen, they drank tea, and I think they had a severe vomiting. So they rushed to the casualty department, or what they call the the OPD or the accident emergency department now. And it was established that the tea contained poison, that is arsenic. And the doctor asked, the nurse asked the doctor to attend to the patients, but the doctor failed to do so. And one of the 3 patients subsequently died. And when they sued, it was established that the defendant, that is the hospital and the doctor who failed to attend to this patient brought under emergency, were negligent. They were liable for negligence. However, the plaintiff failed on issue of causation. In other words, the injury and the death could not be blamed on the breach of duty of care by the hospital and the patients. Then I'm sure you'll be wondering, why was it so? Because even if the patient had been treated promptly, his condition was so serious that any treatment could not have saved his life. In other words, if the doctor had even attended to the nurse's call to attend to the patients, it would not have made any difference. The patient will have still died, because those who know about poisons, arsenic poison is a very serious form of poisoning, which is more or less irreversible in terms of the damage that it will cause to the human body. Yeah, and for that matter, it may well happen oftentimes that a plaintiff or claimant will be able to prove existence of a duty of care and also breach of the duty of care, but he or she may fail when it comes to causation. He or she may not be able to establish the third requirement, that the injury that he or she is complaining about was as a result of the breach of duty of care by the patient. So let us keep that in mind. The Bradford test, as you notice from your general law of tort, has been applied time without number. And in the case of Holt against Edge, right? The case of a Holt against Edge decided in 2006. We see the Bradford test being applied again. There, the plaintiff patient, whilst in the shower, that is why bathing, telephoned her GP. GP is like her local doctor. And she did not see her own GP until the following day. Now, 2 days later, she went to hospital where a subcoronary hemorrhage was diagnosed. She suffered stroke and later on sued for negligence. Now, during the trial, the GP admitted negligence. The duty of care had been breached, as she had not seen her. The plaintiff had not had the opportunity to meet the doctor earlier than was necessary. However, the patient failed to satisfy causation, failed to show that the delay or the failure by the doctor to attend to her was responsible for the stroke which she suffered. Because the evidence showed that even if the doctor had attended to her at an earlier stage, she had not presented with any history of symptoms to lead the doctor to send her to hospital at an earlier stage. The GPs, if you like, they provide like the primary care, right? They provide the primary care. If they are of the view that your condition is very serious, then they make a referral to a hospital. And according to the evidence, the situation of this patient was said that it would not have actually prompted the GP to refer her to a hospital to treat her for signs of stroke. And for that matter, the stroke could not be blamed on the failure of the GP or the doctor to have attended to the patient early. So let us keep that in mind. Another point worth noting is that when you are dealing with causation, you may also be contending with what we call multiple causes of the claimant or the patient's injuries. In other words, where there are more than one sorry, my line. Sorry, my line went off again. Yeah, it may also happen that the injury that you are complaining of, for example, emanated from more than one possible cause. So where that is the case, how do we satisfy the requirement of causation in order to hold the defendant or the hospital liable for what you are complaining about? And we may want to cite the case of Wilshire against SS Area Health Authority to illustrate. In the Wilshire, a premature baby suffered from a number of disabling conditions. The claimants or plaintiff claim the blindness from which the baby suffered was caused by an excess of oxygen. There were, however, a number of different possible causes. During the trial, medical evidence was inconclusive as to whether the excess of oxygen caused or materially contributed to his condition. The lower court held that a defendant had caused the injury, despite the fact that it was impossible to pinpoint the precise contribution the negligence made to the baby's condition. Eventually, when the matter went to the English House of Laws, the appeal was allowed and the courts applied the decision in McGee against the National Court Board. I'm citing these cases on assumption that we all pass a law of thought. So these cases are just a revision word for you. So what the court said was that, well, even where you have multiple causes, it still turns on the plaintiff having to show on balance of probability, or if it were again, I would say on the preponderance of what probability that the excess oxygen caused or materially contributed to the risk of injury. And the court was of the view that the plaintiff or the claimant was not able to prove this. And for that matter, the plaintiff has not succeeded in showing that the blindness which the child suffered was as a result of any excess oxygen which had been administered. So let us keep that in mind. But it is also pertinent to note that the court can sometimes apply what we call like the common sense approach to causation. There is let me give you this illustration. There's a case, right, pending before the court, for example, and this is the bare fact, because it's still sub judice. I won't give you all the fine details, but the facts are this. A patient who was quite healthy, underwent antenatal care at the facility. She had a normal vaginal delivery, and the patient was asked to come for the routine checks. The patient did not go. The routine checks were supposed to have been attended within a week to 2 or 3 weeks. The patient never went. And after well over 3 weeks, the patient claimed that she started bleeding profusely. And for that matter, she was taken to the nearby hospital. And at the nearby hospital, they attempted a procedure to contain the problem. But I think the attending physician was also not very good. So he made a referral to Confanoche Hospital, which is like the tertiary hospital in the region. Now, when it got there, they too conducted a procedure which involved removal of the uterus of the patient. And later on, the patient has sued the very facility where she went for delivery, claiming that her uterus has been removed as a result of retained products from delivery, as is well. Retained products from the other placenta or from the delivery. So therefore, the patient is trying to blame the injury that she has suffered now, i.e. the removal of her uterus, which means that she cannot deliver again on the very facility where the patient has undergone normal delivery. So in a case like that, we want to find out whether, of course, there are a number of issues. You even need to find out whether there was a breach of duty of care, which will be difficult to prove in the circumstances. But assuming that is even proven, can you blame the removal of the uterus, for example, on the very facility where the delivery took place and all that? Or can we say that there have been other break in the chain of causation and all that? But having said that, the point needs to be made that there are times that the court will take what they call like the common sense approach in trying to make a determination as to whether the injury a patient is complaining about can be blamed on the tortfeasor or cannot be blamed on the tortfeasor, as it were. But the 2008 decision in Bailey against Ministry of Defense and another is quite instructive, where the English Court of Appeal held that in cases of cumulative causes of injury, that is where you have more than one cause of injury, and where there is no certainty of medical evidence of a probability that, but for the defendant's negligence, the injury will not have occurred. It is only necessary for the claimant or plaintiff to be able to prove that the negligent act of the defendant was more than a negligible contribution to the plaintiff's injuries. In other words, where you have computing causes, right? But medical evidence is not quite solid as to whether a particular cause was the most material cause of the injury, which the patient is complaining about. In that case, all that the plaintiff will need to do is to show that despite the fact that there are equally other potential causes or other causes of the injury I'm complaining about, what the defendant did was certainly not a minor or insignificant cause. And the defendant's breach was more than just negligible cause of the injury that I'm complaining of, even if that cannot be demonstrated to be the dominant, the substantial material cause. Insofar as you can show that the defendant's negligence was not just insignificant. It was something not just negligible. You have succeeded in letting the court come to the conclusion that the defendant's negligence can be blamed for the injury that you are complaining about. So let's pay attention to that. And that is why in the case of Chappell against Hart, Justice Kirby made the point that in trying to consider the question of causation, it's essentially a question of application of common sense. And this is how he put it, quote, if, but for the negligent act or omission, the actual damage suffered by the plaintiff will not have occurred, then one can conclude in the plaintiff's favor, okay? If, but for the negligent act of or omission, the actual damage suffered by the plaintiff will not have occurred, then one can conclude in the plaintiff's favor. So here, you see how the court is just trying to say that, okay, can we say that if the defendant had never done what he did, which we call like the breach of the duty of care, is it the case that the plaintiff will never have suffered what he's complaining about? If the answer is yes, then we can say that the plaintiff's injury can be blamed on the defendant's negligence and so on. But we also need to appreciate that if the damage or injury complained about would have occurred in any event, that negligent act of the defendant will not be the legal cause. That is to say that even if the defendant had not done the negligent act, the plaintiff will have suffered the injury in any way. Then despite the fact that you have succeeded in establishing, sorry, my line went off again. You finish pretty soon, don't worry. Okay, you see, sometimes the injury that the plaintiff is complaining about may not be a positive act. It may rather be an omission, as we saw in the Bulaito case. And the Bulaito case, the omission here was the fact that the pediatrician specialist and the nurse, they failed to attend. And then during the trial,